Alrighty, folks, we're getting geared up. I don't normally wear a headset, so I apologize. I have a headset on today because my weirdo speakers wouldn't work, so I'm just not used to wearing a headset. So just bear with me. Okay, 3 o'clock. We're going to give folks a couple more minutes to get in to make sure that we have our folks here. Let's see here. Yeah, we got more folks coming. We're just going to wait a minute or two here. So grab your coffee or your popcorn or whatever. We'll be live in just a minute here.
Are you going to give me an introduction, or do you want me to give you a two-line?
I'm going to give you a mini introduction, Scott, and you're going to do the rest. Very short. You introduce all the parts you like.
Why should we listen to him? So.
And Scott, how do I pronounce your last name?
Courtney.
Courtney. Okay.
Yep.
All right. Okay. All right. So it's about 3:01. So we try to stay as on time as we can. So good afternoon, everybody. I'm Teresa Barton. I'm one of the folks who runs this peer roundtable group. Well, today it's actually a presentation from an attorney, which I'm thrilled to death because we're going to talk on some really hot buttons that relate to personal injury cases. And so we're waiting for everybody to sign in. Let's see. A couple people are having some tech trouble. I was having tech trouble too. So what's new? Let's see. Some people are saying they had to register again. Amy was having trouble. Kate, I'm assuming you and Julie are looking at the chat to see the kind of problem, the tech problems that folks are having, see if you can help them. All right. Let's see here. Let me give one more. Oh, we still got people struggling. Let me give it another minute or two till the tech problems solve themselves. I see some names I don't recognize very often. That's great. I'm glad to see folks coming on that aren't always on our meetings. You guys know this is our monthly meeting, which is always the fourth Thursday of the month at 3 o'clock. And this is always with a guest, well, most always with a guest speaker, normally for CEs. And then remember, we have 3 peer roundtable meetings a month, crazy as that is. We have 8:30 in the morning on the second Tuesday. Then we have a 3 p.m. on the third Wednesday. And then we have a 5 p.m. for a lot of the newer guardians who are working full time. We have a 5 p.m. on the last Wednesday of the month. Those are all roundtable meetings, and there's no CEs because there's not an exact agenda for those. So there's not a particular CE, you don't get CE credits for those. It's really just shop talk and resource sharing and all that stuff. So, all righty. 3:03. Julie and Kate, are you thinking that the tech stuff is resolved, or are people still struggling?
It just said that they had to register twice, and I have no idea why that would happen. But
a couple people said it.
The confirmation link didn't allow them to join. I'm not sure why.
All right. Well, okay. Let's wait one more minute then, because maybe other people are trying to log in and they're fighting with it. Okay. All right. So 3:04, we're going to get rolling. All right. So my name's Teresa Barton. I run the peer group in an effort to help guardians have a lot more information, resources, solutions, because I did this work for 30 years and I have a good idea of every problem that you run into, and I like to try to make it easier. So I'm always looking for speakers that have a perspective that kind of aligns with guardians, like emotional personality. And Scott and I ended up getting connected. He does personal injury work, and listening to him talk, we ended up having multiple conversations. He kind of talks the walk that we do. It's a little bit more aware of the care and the client situation maybe than a lot of attorneys and other people. And so I really liked listening to him talk. I got the feeling that he understood what the heck we're dealing with. So Scott, I'm not going to say much other than I want you to introduce yourself and tell everybody just a little bit about yourself, and then get this started. Our plan is, guys, we're going to try to keep the questions to the end. Unless you've got a burning question, put it in chat. If we can, maybe we'll bring it in, but we've got a lot of data to get through, so we're afraid we'll run out of time. So Scott, can you hear us? Is everything working?
Yeah, I think it's all working, but now as I'm trying to get the video back on track here. Here we go, and get to my share screen. I'm an attorney. I've been handling personal injury litigation for better than almost 34 years, something like that. And my focus has been on long-term care litigation for virtually my entire practice. In more recent years, I have been working, doing a lot of long-term care litigation, not nursing home, did a lot of nursing home litigation in the 90s, but now we're doing more group homes and home health and different things like that. Am I sharing my screen or not?
I'm only seeing the word Zoom.
Yes,
so
you are sharing your screen.
Okay.
Really? I'm only seeing Zoom also. You're seeing my ward was wronged?
No, you have to pull up your presentation.
Right. Take 2. Okay, here we go. One presentation, share. Same thing.
There you go. That's great.
I
Oh,
did have it.
stopped for some reason.
Okay. It's
Did
'cause
you hit escape? Okay,
Yes.
stop again.
Okay, my ward has been wrong, that one?
Now we
Yeah.
can see it.
Sorry for that. I promise we did try this about 10 minutes ago. So, we handle in more recent years, meaning the last 10, 15 years, we've been handling a lot of abuse, neglect, and exploitation cases involving vulnerable adults. And as I met Teresa and learned what your organization does, I thought, hallelujah, I'm glad to know you've got this network of folks to collaborate with one another. A lot of times I'm dealing with guardians who may be family members. I also deal with some other guardians who are professional guardians as well. And my screen is not moving. Here we go. There we go. So, looking at what we do if we've got a claim, and one of the questions that Teresa asked me to address is, how do I make a decision about whether or not to even talk to a lawyer? And she explained a little bit of this background about the concern about all the work and the time would be involved. And so let me talk to you a little bit about what's a lawyer need to get started. And we describe it frequently as a story. In my world, in my office, we put the story when you first call on a pink sheet. And so you'll see these little pink boxes a few times through my presentation here. But it's not like you've got to come in with a whole bunch of documentation and have the case all outlined and everything. That's really cool if you do that. And my legal assistants love it when you do that, but that is not necessary at all. People come to us with a story. Now, a lot of times the stories are illustrated with key documents or photographs or something like that. Looking at this case, this lady came in and she told me that her mother had a fall and there was a bump on her hip. And she showed me this photograph and I wasn't all that impressed with just a fall. And then she shows me the picture and the bump on the hip. And I'm like, well, what's that? And then I see this x-ray.
Hey.
Smokes. And this was discovered 10 days after the fall.
Oh,
and so it's one thing to hear the story about she had a fall and then 10 days later she has a bump on her hip and it turns out her hip's been broken. But then you see how severely the hip is broken and it changes the story entirely. So it's a story, and we describe ourselves as we are storytellers. We try to tell our client's story in the best way that we can. So what's it cost to inquire of a lawyer? Well, little time to tell the story. Y'all are professionals. Your story is going to be a little bit organized. Not everybody who calls into the office is very organized. There's no retainer to call a lawyer about a personal injury, abuse, neglect case. There's no retainer required. It may be that you need a court order, and I understand that's sort of jurisdiction to jurisdiction a little bit. You may need a lawyer, an order to hire a lawyer, but most lawyers will investigate a claim before you sign a fee contract. And so you can tell their story. You can give the lawyer permission because the lawyer is going to gather the documents. And so I usually ask for a HIPAA authorization and we start gathering a few documents. And then we decide where we go from here. What can we do with this? And it may not be anything, and it may be something that we can go forward with, in which case I'll need you to sign a fee contract. You'll need to go to the court and get it approved, but I'll help you with that in whatever way I can. I am not a guardianship lawyer, but I kind of bounce into the edges of them from time to time. So let's start really, really basic. Perhaps you covered this in your civics class. For some of us, that was many, many years ago. But the elements of a claim, of a legal claim for civil money damages, we describe 3 elements of a claim. We've got to have negligence, causation, and damages. It has to be some sort of neglect or wrongdoing. The real easy example that we use out on the streets is, well, when you see a red light, you stop. And so people that run red lights, they have been negligent. They had a duty. They didn't follow their duty to follow the street signs. They ran the red light. But if that's it, there's no causation or damages. You don't get a claim just because somebody scared me to death and they ran a red light in front of me. We've got to have causation and damages. And so we describe it frequently as after our negligence or some sort of misconduct, because it doesn't seem fair to call abuse where somebody strikes somebody with a weapon of some sort. Neglect is not a strong enough neglect is not a strong enough word for that. But then we've got to have causation. And so did the wrongful act cause injury or harm? We do hear this story from time to time, particularly in medical litigation that we do some of. They describe that, well, the doctor did thus and such, and they missed something, and they didn't get caught till 3 weeks later. And if it hadn't got caught 3 weeks later, they would have killed me. Yeah, but they didn't. And so there's no causation for any significant damages of any sort. And so we look at the harm, the damages. What's the harm that was caused? Is it significant enough harm to justify legal action? And that kind of differs from claim to claim. In a medical malpractice claim, the level of harm to justify litigation is pretty high. It's really high. And then we also ask on the damages, all right, so we go and we get a verdict of some sort. Where's the money going to come from? Or is there any sort of liability insurance that will provide coverage on these things? And that's where you need to talk to a lawyer. I'll give you an example. I gave myself a reminder here of the example. So sometimes there's liability insurance in places that you wouldn't dream. I'll give you the example is a number of years ago, I represented somebody who had been shot in a drive-by shooting. Well, we don't know who shot. Maybe they learned who shot, but they're in jail if we know who it is, and we're not going to get anything from them. But guess what? If they're in their car when they got shot in a drive-by shooting, oftentimes, usually, if there's uninsured or underinsured motorist coverage, it's going to apply. And you're going to be able to make a claim against your auto coverage. Now, who would have guessed that? I know I wouldn't have guessed that before I was a lawyer. So I want to ask a lot of questions. I'm going to give you a couple of scenarios first. I'm going to start with criminal misconduct that causes harm. And so we're going to look at 3 different scenarios, one involving a crack dealer, one involving group home staff, and another one involving family. So, these pictures that I've got here, this happened in a group home, and this boy, even in this day and age, believe it or not, he got beat with a belt buckle on his back. And I'm just appalled that those things still have, I say a boy, he's a man in age, but he's childlike. And so let's look first of all at the crack dealer situation, because sometimes y'all get involved because somebody has not handled their addictions very well, or they have addictions and they don't get over it. And so let's use the example of you have a crack dealer who exploits your ward sexually, financially, maybe causes injury. They sell her out for prostitution, for drugs and cash and the like. Is that wrongful conduct? You betcha. But are there going to be any claims there? Well, the reality is this: we're never going to make a recovery from the crack dealer. The drug dealer is liable. Technically, you could bring that claim, but there's not going to be any insurance that's going to cover it. And the reality is the drug dealer's money isn't really accessible. And so that's why you never see claims like this. Can you pursue it? Yeah, you can pursue it. It's a whole lot of time and effort for nothing, though. Now, there are some exceptions, though, when we deal with criminal activity. And believe me, all my examples here are real examples. And so let's take the crack dealer who's sexually exploiting a childlike young lady in an apartment complex, and he's pimping her out for prostitution. But everybody in the apartment complex knows this is happening because there's just a parade of men that goes into apartment number 127 or whatever. And it's no secret out on the street about what's going on. Well, now we have some more interesting facts that, is this primarily the issue with the scoundrel who's pimping her out? You bet it is. But you know what? An apartment complex also has some duties to keep people safe, and especially if they know they are vulnerable. And apartment complex, we're going to have significant legal issues of duty. But in that case, we were able to bring a claim against the apartment complex because they knew and they darn near participated in keeping it quiet so they could keep the parade of people going and the like. And so that gets a little more interesting. So different exception. Let's put the drug dealer that actually has a reputable job and they also work in a group home. And that's where he met the ward and this misconduct of whatever kind you want to call it. And now we're in a group home and there's some sort of criminal misconduct. It doesn't have to be a crack dealer. It could be something else, some sort of criminal conduct. But the group home may be liable. And the group home, as we're going to see in a minute, has some different obligations and is going to be insured. So let's move to scenario number B, the group home staff. So let's first of all put this criminal conduct in the context of a nail salon up at the strip mall, and there's a nail salon and the ward's in there. And the salonist, is that what they call them? A stylist? I don't know. I haven't been to a nail salon, but they get upset by something said and they hit her and cause some sort of injury. And the nail salon staff may even be arrested and charged with abuse. And you think, well, is there a claim there against the nail salon? Well, generally, we have this legal principle that an employer is not generally liable for the intentional torts, criminal conduct, intentional torts of their employees. It's called an ultra-virus act. It's outside the bounds of the law. I hired you to take care of nails, to provide good service. And once you step into the point of sexually assaulting somebody or hitting somebody, you are now beyond the bounds of what I've hired you to do. And you are no longer my employee once you overstep that line. So in that scenario, there's not going to be any liability on the nail salon unless the employer knew that this is going on and had some sort of notice. That's usually a hard hill to climb, but it's the kind of thing that lawyers can poke into, and maybe somebody whispers in your ear about what happened and can do something about it. Now, let's put that abuse in a group home. Well, group homes have a special relationship. And Florida law has there's some case law out there that describes that when a caregiver agrees to provide care for a developmentally disabled person, my guess is that's the lion's share of your wards. When they agree to care for a developmentally disabled person, there is now a special relationship that's created. And so we'd run into these scenarios where a group home employee abuses somebody, hits that boy with a belt, throws a shoe at him, breaks his nose, or whatever the case may be. And even when the group home had no idea that this employee was prone to going off, and they'd never done it before, they'd always been docile, didn't see it coming at all, the group home is still responsible under Florida law. Now, there's a lot of lawyers that don't know that case law, and that liability applies even though this is an ultra-virus act. Let's move to a different scenario. Family exploitation. Been involved in some of these too. My guess is you've heard some of these stories. So nephew moves in with Aunt Edna. He's going to provide care for her. He's going to help her in her latter years. And she has him running some errands and the like, and he has her credit cards and he has access to her checking account. He takes her money, takes it for personal expenses. And look at the first part of this. First of all, let's say he takes this money and he runs up $15,000. We've probably all seen bigger accounts than that too. And he just wastes it all. Video games and high living, at the bar, whatever the case may be. He just wastes it. Well, there's no claim that can be brought if we don't have an avenue of recovery. The money's been wasted. We'll never get it back from the video game producers and things of that nature, or his buddies that he was drinking with on Edna's money. But let's take it another step, and we've had this case. This is working so well with wealthy Aunt Edna that he converts $125,000 of her money to get his own little house. And he explains to Edna, oh, we're going to move in together, and I'm going to take care of you for all your remaining days. And puts the house in his name, though, not her name. And of course, there would be a scenario where that may be okay if it's in her name or their name, perhaps even. But he says it's just in his name. And she's delighted to know that. And then other family members get wind of what's happened and the like. Well, under that scenario, his house is an asset that hasn't been wasted and perhaps can be a recovery. We've had this situation where we took the house and that was our recovery. And frankly, we flipped it. And actually, there were two houses. And so there is an opportunity to bring a claim if we can get to the assets, if the money is someplace that it's still accessible. But think about this, you got to move fast, because if the nephew gets wind of what's coming, he may sell the house and then the assets may not be accessible anymore. And there's different things that lawyers can do to cloud the title of the house to prevent that. But you got to move fast into that scenario. All right, let's shift to negligence scenarios. We all understand the issue of automobile accidents, and so I'm not going to bemoan that kind of a scenario. But there are in your world and in my world, we run into other situations. And so the scenario is this: the driver for a group of facilities, ALFs, he's got the facility van, and and you can see the wheelchair ramp there, and they load them up and take them, but he doesn't load her up the right way. And as he goes around a corner, the wheelchair tips over and it turns. And so the questions we're looking at, and these are all different answers: who's the driver work for? He worked for one company. Is that his employer? Is he working? And turns out it is his employer. But who owns the van? In this particular scenario, it was yet another company that owned the van. And that gave us some other opportunities. And it was a related company that's trying to skip out of liability by breaking up their land holdings and their license holdings and who runs the kitchen and everything else into different companies. But it turns out somebody else owns the van. So here's just a snippet of the case. Is the driver picks somebody up at TMC, a sister facility, and then he's going to run over a few blocks away, and he's going to pick up Ms. Ward over at what I'll call Green Acres. And as he leaves Green Acres, he's going to run one of them to an audiology appointment and another one to another appointment. I don't remember where it was. And so as he pulls out of Green Acres there, he makes a right turn out of the parking lot, and he gets down to the next T there, and he makes another right turn onto the parkway, and then he gets down to where the accident happens there. And this time, the last turn, it's going to be a left turn. Now, the driver's already 30 minutes late for the appointment. And so you can imagine that there may be a little anxiety because my job is to get these people to their appointments on time, and I'm late. And he goes around this last turn, and this is the first left turn after he picks up my client at Green Acres, and the wheelchair goes flying off and we can think of the come over darling turns. You make a left turn and she leans off to the side there, and it turns out that the wheelchair falls to the side. She's strapped in, and unfortunately, her head goes into the equipment, and it actually killed this lady.
Oh, my.
She was gone within a day or so. And the photos that somebody took, I don't remember who, were really, really telling. And it made sense because if you strap the wheelchair in the right way, it doesn't tip over. But the photos were very telling that you see the red strap on the one wheel there on the back, but you see how they have, how the wheelchair has collapsed in that direction as he went around the left turn. And there's no red straps on the front either. And so it's unstable or unstable. And it collapsed, and she went and had this tragic, tragic accident. The real tragedy in that case is they didn't fire the guy. He had a long history, and he did it 4 more times before they, and 2 of which caused injury. I guess 3 of which caused injury before they said, no, I don't think you can drive for us anymore. So let's move to another negligence scenario. And these are, this is actually a recent matter that we've had. Lady's got a prescription for morphine. The dose ordered was 10 milligrams. Ward's given 60 milligrams. How in the world that happens is anybody's guess, but we'll figure it out. But it's the clear overdose, right? And so there's negligence. Remember, I've got to have negligence, causation, and damages. So we have clear negligence. And in this case, it causes respiratory depression. And she began to wheeze and gasp for air. She's foaming at the mouth because it's a big overdose. But back up a little bit, because I get this call from time to time. So I'm given a double dose, or somebody in a nursing home is given a double dose of medications, but it doesn't really cause any harm or injury, or nothing that's discernible. And somebody may wonder if there's a little bit of something, but you know, the reality is you can probably double dose your heart medicine or your lipids or whatever the case may be, and it not cause any harm if it just happens once or twice. But in this case, she actually ended up with an anoxic event. She started having seizures. She's still alive, but there were some questions initially: is she going to survive? And so how do we analyze this? Well, the first question is, where does it happen? Because that's really important if she's not going to survive. If it happens in an assisted living facility, if it happens in a nursing home, those 2 groups of facilities are governed by Chapter 429 and 400. And those statutes specifically says, if it happens even at the hands of a nurse or a doctor in a nursing home or assisted living by their staff, then it's not medical malpractice claim. And so under that scenario, if it causes significant damages that are worth pursuit, it's going to be actionable just about every time. But what if it happens in a hospital or under home health? And in this case, it did happen in a hospital. Well, now we have a different set of statutes and procedures. This is a medical malpractice claim now. The medical malpractice rules in Chapter 766 apply. Med mal claims are very expensive. They're hotly, hotly contested. The example I use frequently is we had to try a case a number of years ago involving a lady who goes in for a hysterectomy, and the doctor puts a hemostasis clip on her ureter and doesn't recognize it and sews her up. And bad things happen when you clip off your ureter. But the reality is, about 8 months later, she was back to where she was before. She'd had to have a colostomy bag for a while and some other procedures. But 8 months later, she was really about how she was before. And the insurance company was very clear that they were not happy that we brought this little med mal claim and plagued them with this. And we won, but we always knew it was not a huge case, because nobody's saying, oh my, she's going to hurt for the rest of her life. She's not going to be able to walk or anything like that. And so med mal claims are always hotly contested. So let's go to the morphine overdose. If she dies from that overdose, the next question is, do we have any survivors under the Wrongful Death Act who can bring this claim? Because Florida, believe it or not, has this free kill exception. that if there's no survivors in a medical malpractice claim, no minor children can bring a claim for the loss of their parent. A spouse can bring a claim for the loss of their spouse. But an adult child over the age of 25, for the purposes of the statute, an adult child cannot bring a claim for the loss of their parent due to medical malpractice. Well, they can bring a claim technically, but it's limited to the medical bills and the funeral bill, and you'll outspend that before you even get the case filed. And so there are no survivors to claim mental pain and suffering from the loss. This is a totally different rule in Georgia, where I also practice. And so there's the med mal free kill exception that we have to be alert to.
Can I ask, so I'm assuming then I, as a guardian, my ward dies, they don't have a spouse, they don't have any adult children, I could be named as the PR to the estate, and I'm sure there's heirs somewhere in the world because nobody came from a dinosaur egg, but I can't, right? I can't do anything.
If it's something where there's negligence like this, it's worth a call to a lawyer, but this is what you're going to hear.
Okay.
And sometimes there are some workarounds, some exceptions, but there are not very many. If it happens in a hospital in Florida and there's no minor children, remember, minor child is a 24-year-old still. If there's no minor children, no surviving spouse, there's not going to be a claim that can be brought.
The only edge I can see that might be a good fight would be is if there's an over 25-year-old developmentally disabled kid, and that might be a fight worth having. Oh, Scott, you went to mute unless I did something. We can't hear you, hon. Can you guys hear? There we go. Now it's back.
It told me somebody muted me. I don't know who.
Okay, yeah, because I'm just thinking if there's a developmentally disabled young family member, child, 26, 27, might be worth the battle, maybe.
It would be worth a look if there is somebody who is financially dependent, like you described. I haven't looked at that in a fair number of years. I've never actually had that scenario come up. Okay. But that would be worth taking a good hard look at the statutes to see if we could work our way through an exception there.
Okay.
Next scenario. Similar. It's a call I had 2 months ago, something like that. Ward's in a facility of some sort. I don't remember what kind of facility, and has a prescription for Eliquis, and they've got some heart condition that's recognized. And the doctor says, look, I'm going to put you on Eliquis, and this is going to help prevent strokes. And so it's going to make sure that you don't develop too much clotting. And so the guardian is paying $900 a month for medication management. And believe me, the guardian's sort of stroking at this because it's the only medication that they're giving. Wow. And so once a day, they're going to give a single tablet, and they're paying $900 a month for this. And so they're kind of stroking over that. But then the killer was they discover a couple of months later, well, wait a minute, we've been doing this for 3 months and I still have the whole package there. I give you a 3-month supply and you haven't given a one. And so, but the good news is nobody had a stroke. Now, this is a different story altogether. This is a really easy story if it turns out that you learn this and then they have a stroke. Oh, my. Hold on. My computer's telling me it wants to restart. We don't want it to do that. There we go. And so, do we have negligence? Absolutely. You got to give the meds that are being prescribed, and especially if you're getting paid $900 a month to walk them down the hall and give them to them. Now, if the facility refuses to refund the $2,700, 900 times 3, well, that presents some interesting issues, and I can't imagine that they would refuse. But I shake my head all the time at things that happen. I wonder how that happened. And so if they refuse to refund the $2,700, then we might have some interesting issues to look into. Is that exploitation? Well, in the right setting, if it's not in a nursing home, if it's not in an assisted living, then you could bring a claim under 415 for exploitation. But it's probably not worth it for $2,700, although any lawyer who does this work is going to at least write the letter to see if they say go jump or not. And frankly, you can probably write the letter too to get the money back. So then we look at the question of, well, what are the damages? $2,700? That's generally not worth filing a lawsuit over. But then we also look at other factors. And there are always other factors that we need to consider and explore. Using this example, we have the civil theft statute that allows for treble damages. And I'd feel pretty comfortable arguing that scenario, that you've taken the money, you haven't provided the services, you know that, and you've intentionally taken the money. And so I write the statutory letter and say, you owe us $8,100, you owe my ward, my client, $8,100. And they got 30 days to send the check. Now, they're not very happy about that, and they're going to push back about that. But then we've got other factors as well. I already mentioned Chapter 415. Chapter 415, you're probably familiar with, is the abuse, neglect, and exploitation of a vulnerable adult statute. And in that scenario, a prevailing party, a plaintiff or defendant who wins, the prevailing party gets their attorney fees and costs from the other side. So if we end up with a terribly hard-headed facility that just says, no, we're not going to give the money back, well, we've got some different things that we can do. And sometimes we also run into contractual fees and costs that can make something like this worth pursuit if somebody's just got their head in the wrong place and won't give the money back. So let's talk about residency agreements and arbitration clauses. Gosh, I look at this slide, there's way too much information on there. I'm sorry. And so all of you, I'm sure, have signed residency agreements and inevitably there's going to be an attachment B or K buried deep within it. Maybe it's not an attachment, an agreement to arbitrate. And basically what an arbitration agreement says is, if we have a dispute between us, we're not going to file any lawsuits, and we are going to let an arbitration panel decide our dispute between us. And that's typically the way those run. And sometimes you run across a few, like this one I've got here on the right side of the screen here, that they use this as a club, that if your monthly rent's late, then, and we have to bring a claim against you, we're going to put it in arbitration. And by the way, you're going to pay our attorney fees and costs. If we have to file a lawsuit or file an arbitration claim to get our monthly fees paid. And so this is a clause that we are aware of that is in some contracts. And I'm constantly scanning these admission agreements to see what kind of language is in there. And by the way, you need to know this. Sometimes we run across where the attorney fee provision says, if we have to sue you, you're going to pay our attorney fees and costs, but it doesn't work the other way. And that's obviously a one-sided deal. And I got good news for you. The Florida legislature looked at that and they said, no, that's not fair. If it's good for the goose, it's good for the gander. And even though your paperwork may not say that, if it's fees one way, it's fees the other way as well. And so the legislature has taken care of that for us, and they got that right for sure. So I wish I could take credit for this document that may help you with arbitration agreements. But this is a really good lawyer who refers some work to me, and I ran across this after she had referred a client to me, and I'm looking at the documents that she gives me. And so her ward, this young man who's been a ward of the state for since he was about 12, goes into a group home setting, and she signs the contract once he becomes an adult. And what she filed next was the petition to confirm the residency agreement that she had signed, because she had to sign it. But she added this next line, except for the arbitration agreement. And I thought this was brilliant. And she describes in the petition here that the guardian believes that I don't have authority to waive this young man's constitutional rights, and it's unlawful to ask me to do that, and I'm not going to trample on this young man's rights. And so, Judge, I want you to approve the contract, but not the binding arbitration agreement. And if you want me to send this to you, shoot me an email. My email will be up again later also, and I'm glad to.
Well, Scott, we're gonna, as long as it's okay with you, we will be sharing your whole presentation with everyone. We typically do that at the end, but we definitely want those forms. I want to stay here for a few minutes, guys, because this has been a burr in my saddle for years. If you understand, there's nothing that the courts gave you as guardian that allow you to just arbitrarily give away your ward's constitutional rights. You don't have the authority to do that. Of course, we're in a catch-22 because the facility says, you want Miss Sue to move into our ALF, you will sign this arbitration agreement. And that is a struggle. Also, Scott, you and I didn't talk about this in our planning calls, but as a general rule, most guardians are not getting the contract authorized to sign it by the courts in advance. It's often behind when the horse is out of the barn. It's often because they've got to get placement. They're in a tight situation. Sometimes guardians do, and maybe more now, do get court authority to actually sign agreements. But if you think about all the agreements that we sign, caregiver agency, DME company, it's kind of endless, the amount of agreements that we sign for wards, and the practicality of getting every single one court order approved before we sign it. Oh, that's pretty big. But this has always bothered me. And I used to keep a Sharpie, and I would, every single contract that I had in front of me, I took out the arbitration clause. It works until the facility says, we won't let you move your ward in to our building unless you sign that arbitration clause. And I always felt like that was blackmail. And I felt like they didn't have the right to make me do this, but I did not have this piece, Scott. And I really appreciate this because it bothers me now. So I love this idea to say, okay, yeah, the guardian signed the contract, which meant it had an arbitration clause, but the attorney filed the petition authorizing me to sign that contract, except for, and I like that. I love that.
I thought it was absolutely brilliant. And it may be that she picked up, because I've been preaching for years to probate lawyers that if you prepare somebody's power of attorney, have a discussion while they're lucid, their DPOA. Have a discussion. Well, do you want your ward or your attorney, in fact, to waive your other rights? And so I've been preaching for years that they should include language in a DPOA that says that they don't have authority to enter into pre-dispute arbitration agreements. We can agree on the back end to arbitrate, but on the front end, even before something arises, you can't agree to it. And that kind of solves the problem too.
All right, so Scott, the other thing you and I had talked about was whether or not to have the attorney prepare the letters or the order at the get-go, the beginning of the guardianship. Is that something else that is helpful, or is that not helpful? Meaning that they put the wording in there that the guardian does not have the right to release any constitutional rights. We've never put that in there, but is that helpful?
I think you could, yes. And I think I've seen that, and I went looking for it and I couldn't find it, honestly. But I think I've seen that, and that makes a whole lot of sense. And think about the cred you've got with the judge when you say, Judge, I'm not going to overstep my bounds. There's a few things I'm not going to do. And for instance, I don't want to deprive my potential ward of their constitutional rights. And frankly, I think the judge is going to admire that and be happy with that.
Okay, this is just something, guys, that I'm Scott and I talked a lot about, because I've never heard anybody discuss this. I've never heard anybody have a document that relates to this. And I don't know if any of you have actually ever considered the risk you take by giving away a ward's right, constitutional right that you actually can't give away. So hot button for me here.
Good stuff. Thank you. Consulting with a lawyer. So I've given you a preview of what we're looking at when you come and you tell us the story, because remember, I just need a story to get started. So what should you expect? You've told the story. My office has completed a pink sheet. I've got the story and a few biographical pieces of information. Who are we talking about and their date of birth and that kind of thing. And so what do you expect? How do you find the best lawyer? How are fees and costs handled? Is it going to be worth it? What's the risk? Well, first of all, these claims involving your wards, these are not claims for what I call high volume motor vehicle accident cases, lawyers. This is unique work. Now, if it's merely an auto accident, have at it. That's fine. Those firms generally handle auto accidents just fine. But if it's happening in a group home and it involves medical issues or assisted living or home health, that is not run-of-the-mill work. And I can tell you in Tallahassee, all those people that have those billboards in my town, they all refer these cases to me because they know this is outside their bailiwick. So you want somebody who handles this kind of work. You want to ask, have they handled claims like this before? Your guardianship lawyer may very well know. I'm a member of the probate or the elder law section of the Florida Bar, and they asked me to chat with them at their annual convention every now and then, and there's other folks like me that do that as well. Nothing wrong with interviewing 2 or 3 firms and asking a few questions. And in fact, I think it's a good idea. A few things that you need to be wary of. If you talk to a lawyer and they want ink on a contract right away, I just pause on that. I know I tell my clients all the time that I'm a bit of an odd bird, but I don't ask for contracts right away. I want to investigate. I want more information. And so if they ask for a retainer, money retainer right away, well, let me tell you, lawyers that really do this, they don't get retainers up front. They don't ask your ward to pay their costs. If they don't think enough about the claim to be willing to front the costs, if they don't think they're going to get their costs reimbursed from the back end, you probably don't have a claim that's worth pursuit, and you're wasting your money, your ward's assets. And so
I want to catch you there, Scott, because we've got a couple of good chats about the arbitration thing. And since that's burned my saddle, I want to talk about it some more. So Diana says, what do you do when the insurance, Medicaid, ALF waiver, whose contracted facilities will not accept the ward if the guardian does not sign the arbitration agreement before moving in? That's question number 1. Question number 2 from Katina says, I generally write the guardian does not have the authority to waive arbitration on the form. I have never had a facility refuse admission thus far. This is a perfect example of guardianship in Florida, 2 completely different examples of what happens. So, going back to that, Diana, I think because you don't have the right to sign it, if you think about it, you don't have the right to give constitutional rights away from your ward. They were given to them by their presidents in the United States. So I think, so Scott, talk about what the options are when the facility says, if you don't sign this, we won't let them move in. What do we do?
So the facilities that I see doing this are usually nursing homes or assisted living facilities, and they'll put it in there, and they'll include language to bolster their legal position. And it includes language along these lines. It said, look, we all understand that you could go to multiple other similar facilities, but we can keep our rates low because we resolve our disputes with arbitration rather than litigation. Now, when you're dealing with group homes and profoundly disabled people that sometimes have very unique needs, I am well aware that you can run into a situation, because I've represented some of these folks, that the next closest, they're up here in the Panhandle, the next closest place they can find for their son, who's chronologically an adult, but he's a child, is someplace down in Tampa. And they're like, I ain't going to see him but once every other month if I do that. And so they have very limited options. And so my inclination is, if you really don't have any options, probably go ahead and sign it, and maybe note that you're signing it under protest.
Mm.
Knows what they'll do with that, but then go back and file that motion that I described earlier and let the court decide.
I like both of those options because you may not know, Scott, we are experiencing in most counties facility limitations, especially with clients who don't have large chunks of income. We have both the elderly crowd and the disabled crowd, both piles. We're experiencing for many clients, especially clients who have any kind of thing that makes them a little bit difficult, the facility choices are getting smaller and smaller. And if you throw in mental health, now you've turned it into a pinpoint. And quite frankly, if we find a facility willing to take a homeless guy who gets nothing but his SSI check and he has an arbitration clause, we're like, we got no choice. So that's what we're up against a lot.
So I think when you go back on the back end and ask the court to make that decision for you, you got pretty good cover. I can fathom a court saying, well, wait a minute, does the facility have a representative here to argue otherwise? And that'd be fair. Let the court figure that out. That's an issue for another day. But it seems to me that's a pretty good solution. But yeah, it's a big challenge. Let's talk. We're running out of time. Let me talk about, were there any other questions on arbitration, Teresa?
Nope.
Good. So let's talk, where did I leave? Fees and costs. Thought it might be helpful to see what a personal injury contract looks like. This is just the first page, but frankly, the guts of it is right there. And this is a standard contingent fee contract. The Florida Supreme Court has a bunch of rules for us, as you can imagine. And this is right out of the rules. And what it provides for is with the fees, it's standard. You can find people that will handle costs differently, and you're permitted to do that. But what we describe is you hire my law firm to represent you in claims for injuries to whoever the ward is, whoever the client, the injured party is. You agree to reimburse our costs, whatever they may be, travel expenses, deposition, filing fees, and the like. And we underline it on the contract, even though, but you only agree to reimburse the cost should a recovery be made. If there's no recovery, you don't owe us anything. We all cry together if we lose. And then the fee is a graduated fee, and it's split up here, and it looks kind of complicated, but it's not all that scary. Here's what it is. If we can resolve a claim before we file a lawsuit, and they answer the lawsuit, the answer is the trigger. I don't like that. I think it's complicated and confusing, but that's what the Supreme Court says. That's what we use. If we can resolve a claim before we're in litigation, our fee is 1/3. Now, this is written to cover all kinds of claims. So it says it's 1/3 of anything up to $1 million, 30% of anything between 1 and 2 million, 20% of anything after 2 million. But the reality is claims don't get resolved for that kind of money early, hardly ever. But if you have to file a lawsuit, well, now we know we're in for a longer course of litigation, and this is not an easy matter, and we're going to be working on it for a while, sometimes for years. And so now our fee moves to 40%. And again, it's 40% of the first million and less on anything after that. If they admit their liability when they answer the lawsuit, then it makes our job easier. We don't have to prove they were negligent. And so our fees stay at 1/3. The reality is that virtually never happens. Not in my world. I mean, that's for people that ran stop signs and stuff like that. And there's just no denying it. Yep, ran the stop sign. I didn't see it. I hate it, but it happened. And then the questions only become, remember, I got to prove negligence, causation, and damages. And so then the question only becomes, well, what if we agree on negligence? What's the causation and what are the damages? There's an additional 5% if there's a notice of an appeal, but that usually only happens after there's been a trial. And 95% of these cases will settle somewhere before a trial is done. Now, the third thing that comes out of a settlement is medical liens, and you need to be aware of that. Most of your wards are probably a Medicaid or a Medicaid kind of plan, or a Medicare plan of some sort. And so any medical bills that are caused by the negligence that we're complaining of, whoever paid those bills is going to have a lien for reimbursement of the bills they paid for. And so that's the three things that come out of a settlement: fees, costs, medical liens. So
can you go back for 1 second? Can you talk about, I just want you to touch on this. This isn't going to be a long enough presentation to get deep into Medicare liens for future care costs. Can you just give them one little framework of what that means and when that comes into play?
yeah, you say that like it's so easy, Teresa. So there is a principle called a Medicare set aside. And the principle is this, is the underlying principle is Medicare says, we'll continue to pay your medical bills after you're getting care that somebody else is responsible for. And we call that a conditional payment. So your ALF driver is in a wreck, causes a wreck, and puts you in the hospital. Medicare says, we'll pay those bills. But let's say the damages are really significant, and as a result, you're not going to be able to live in an ALF anymore. You're going to need more significant care. Medicare says, well, you can settle your claim and we'll get our medical lien, but there is a principle out there that you may need to also set aside money, because Medicare shouldn't be paying future bills that are caused by somebody else either. There's a lot of uncertainty in that world. The place that it clearly applies is in workers' comp claims.
Yep.
It's a mushy for the rest of the world.
Yep.
I know on our end, when we run across that situation, we usually consult with a company or several companies out there that can help guide us through that. Tell us what we have to set aside, if we have to set aside anything, and then guide us on how we set it aside.
That was perfect. That was perfect. I just wanted people, I didn't know anything about that at all as a guardian until probably 5 years into my practice. And I got involved in a very large personal injury case. It became a pooled D4A special needs trust, and then a huge Medicare set aside because this accident happened, medical malpractice, at age 3 months. It basically made the boy essentially paralyzed, more or less, from the waist down for a lifetime. So I learned so much about that. And up till then, I never even heard of the word Medicare set aside. So guys, I don't want you to expect to know everything about it. I just want you to hear it and recognize that this is something that if you're dealing with a personal injury case, that could be something that has to be addressed.
Be aware of it. That's a lot of this is awareness of these issues. So here's, and I think I'm on my last slides. Yes, good. So the question is, well, 3 questions here. Is the effort going to be worth it to talk to a lawyer? Kind of already talked about this. If the lawyer's willing to invest their own money in the claim, advance the costs, invest time, then it's probably going to be worth it for your ward. I tell people from time to time, because every now and then I run across something where I tell somebody, I said, look, I can pursue this claim, and frankly, I can get paid. But at the end of the day, it's not going to be worth it for you. And let me tell you, that does nothing good for my reputation. If you're out in the community saying, well, yeah, he got everything. It all went to fees and costs. And I have no interest in getting you involved in that. And I think the vast majority of lawyers, if they know what the end game looks like, would evaluate things the same way. Sometimes lawyers, especially younger lawyers, don't know what the end game looks like. But I have no interest in nominal settlements. And so I describe for my clients frequently that I'm always asking the question, does it make sense to take the next step? Sometimes I'll have that initial pink sheet, I'll get their story, and they'll say, so do I have a case? Can we take it to trial? I said, I don't know. But I have enough information to say, I'd like to start investing my money and my time in your case. But I may come back in a few months and tell you, I don't think this is a good investment anymore. Let's stop. And so we're constantly asking those questions. And particularly when we're at the point of we're filing suit, because by then we should have a pretty good idea. Is there going to be insurance involved, or is there going to be somebody that is adequately self-insured to cover these? And that's the question. So what's the risk to the board? Well, there's no risk that you owe your lawyer if you lose. 40% of nothing is nothing. Is there a risk of adverse party fees? There is. And that's a risk. But you know what? We're the plaintiffs. We make the decisions regarding settlement. Sometimes we settle cases for less than what we'd like because I've got a client who has money in the bank and they're not willing to take the risk of an adverse judgment that might expose them to the other party's fees, even if it's not a whole lot. And sometimes
and Scott, I think I missed that part. Does the adverse judgment only happen at trial?
Oh yeah, that's only after trial.
Okay.
You're not going to run into a problem of that before trial. And remember, most cases settle, and they settle all along the line. Sometimes before we file suit, sometimes after we file suit. I did a mediation yesterday. Mediations are confidential, but they learned a whole lot about my case. And basically the response was, we're not ready now, but please, 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 let's have a discussion in a month because we will be ready then. Okay. And so most cases settle. And if the case settles, there's no risk to the adverse party or to fees from the adverse party. Okay. Now there is this issue, and Teresa did a good job of pointing this out to me a week or so ago. So as guardians, you do have this unique, interesting aspect of your, that there is a risk potentially of doing nothing. And so use the example, let's go back to the lady who is tipped over in the wheelchair because her wheelchair wasn't strapped down. If the guardian there had said, I'm not, I like those people. They were friendly, nothing intentional. I'm not going to pursue any claims there. And I'm going to walk away from that. I'm not willing to do that. Well, the risk would be if that lady's children or somebody who has a role in the estate comes back and says, well, wait a minute, why didn't you pursue this? And, this is a valid claim. Well, you, the guardian, you have some risk if you don't do anything. And so one of the things that you can do is you can protect yourself as a guardian. If there's a question about whether a claim ought to be pursued, then it seems to me the best thing to do is talk to a lawyer or so. And if you conclude after consulting with the lawyer, especially if you're kind of sideways, if you got a family that's difficult, and I know that's the bane of our existence, isn't it? So, and so if you've got somebody like that, get an opinion or so and go to the court and say, Judge, I'm not going to pursue a claim, and this is why. And by the way, I've got these 2 or 3 lawyers that I've talked to, and this is what they've told me. And so that's why I'm not going to pursue this claim. And the court's going to understand that. Remember, the courts are the judges are lawyers also. They'll understand that. Perhaps they want to talk to a lawyer or something like that and understand what's going on. And I know it can be frustrating. There's a lot of my brethren lawyers who will decline a case, but they won't tell you why. And I always figure if you understand why I'm not taking your case, and we end up in a whole lot better position down the road.
And Scott, thanks for bringing, Scott and I talked about that because I think it's one of the risks that guardians don't recognize. It's not, there's kind of two schools of thought. One is, if you can, should you? And if you can, shouldn't you? And that's really something to think about. It's not just in personal injury. Think about it in Medicaid planning. Like if you decide to go to an attorney and do Medicaid planning, or your ward has $100,000, so maybe you don't need to do Medicaid planning. If you're not going to use an avenue that is available to you, get a court order that says this was a fiduciarily wise decision and we're signing off on it. So not just getting court orders to take an action, but getting court orders to not take an action to protect yourself. That's the best way to go about this. And Scott, you may not recall, but we never, well, almost never go to court without our attorney, our individual attorney representing us as the guardian. We add attorneys sometimes, you, for example, or maybe an attorney in litigation or something else. But theoretically, every guardian, at least under 744, has an attorney representing them. Now, when we get into guardian advocacy, it gets a little hairier, but we should have counsel. They should be good attorneys, and they should help us, advise us, counsel us through this. But I just want you guys to just let that kind of roll around your head. If it occurs to you that you should do it, or maybe can, you do the assessment, you have documentation, good documentation of all the assessments you did, then ask your attorney, should I be getting a court order not to move forward with this because this crazy sister in Alabama is bananas?
I've
Okay.
met that lady.
Okay, so we're going to do a couple things. Number one, if you guys want to come off of mute and either ask a question, if you're uncomfortable with that, you can put it in chat. I've got one from Diana. If a ward who is residing in a nursing home with a community agency paying for the nursing home costs due to no income or assets by the ward has an injury caused by the staff, who's the plaintiff? The ward or the community agency? Good Lord, Diana, it's always you, baby, that has these terrible situations. Scott, do you get that, what she means by that?
I do. The one with the claim is the ward.
Okay.
But when we bring a claim, and I presume this is going to apply to the community agencies as well, if I bring a claim on behalf of somebody and they've incurred costs from the VA, for instance, or TRICARE, the VA and TRICARE, they will actually send me a letter and say that you are required to bring our claim as well. And in fact, you should put this paragraph in your complaint if you file a lawsuit. And the paragraph says, the United States of America has a claim for the medical bills. And no kid put all that out there. And the same applies with Medicare and Medicaid, that you are required, the lawyer is required to bring those claims for those entities, as well as, and their claims, of course, are for money damages paid for injuries that were treated by healthcare, presumably. But the ward also has a claim for non-economic losses. And so does that answer the question? I think it does.
And you guys, if you're ready to, if you want to talk, if you feel courage enough to get on and ask a question, come off of mute, raise your hand, put it in chat. Love to have more engagement. We got a little bit of time. It's 4:07. We don't have, unless Scott has to run, we don't have to jump off here.
No, I'm good. There's Diana.
Good girl.
It kind of answers the question, but not quite, because where does the community agency who's paying the nursing home fit into all of this? I just don't, I've wondered, you know, because this is something that could happen to my particular ward. And I'm just wondering, because she's fallen already, I'm just wondering if something happens, do I go after the nursing home, or does the community agency who's actually paying the bill have more of a right to go after the nursing home?
And Scott, I want to just help. I want to translate a little bit what Diana is saying, because she's trying to protect people. So let me explain to you what this looks like. There's somebody in a hospital. They need a guardian. Don't have one. Public guardian won't take them. Professional guardians won't accept them. So the hospital makes a deal to A, pay the guardian at some rate, and B, pay the facility care. It's coming from the hospital until resources can be found for this ward, if ever. It's very dicey, very dicey. The hospital is writing the check to get this ward out of the hospital into an ALF or into a SNF. And all separately, on top of that, maybe they're paying the guardian, which is a whole nother kettle of fish. But the hospital, let's just separate paying the guardian. Let's just look at the hospital is paying for that person to be in the ALF to get them out of their hospital because they can't get them out any other way. That's the hot button here.
I got to tell you, I was not aware that that would happen.
Every day.
That's intriguing to me.
Yeah, when you and I have time to meet in person, I'll walk you through the program we have called CHG, which is a way to resolve some of that. You and I didn't even talk about that. We had so much other stuff, but we'll talk about that some more. But these are the kind of problems that, so if the hospital's writing the check, the guardian is consenting for treatment in the ALF or in the SNF, and the SNF does a medical malpractice, but the guardian was not, nor was the ward, paying for the care in the ALF, but the guardian was consenting for the care in ALF.
Well, keep this in mind, some general principles. The duty, the nursing, the SNF unit owes a duty not to the hospital so much, but to the ward.
Okay.
And the majority of the claim, the lion's share of the claim is for the ward. Does the hospital have an interest in it if they're paying the bill? They probably do. And maybe that's where your lawyer, your tort lawyer, gets involved with the hospital and says, hey, this is going to be expensive, but you've got a pretty significant interest here. Well, first of all, let's look at the paperwork and see what your interest is. But I think they probably have an interest in it, just like Medicare has an interest in the lien and future needs and things of that nature. And with the hospital, you might get a little bit of assistance. Well, maybe you can at least give me access to the doctors that can help me build my case. Medicare, so Medicare has what they call never events. A bed sore is an example that a bed sore should never happen in a healthcare facility. And if it happens in a healthcare facility, Medicare sees that and they say, we're not going to pay you to repair your own bed sore.
Wow.
Same thing for if they see a surgery and there's instruments that have been left in the abdomen, for example. Medicare is going to say, no, you're on your own for that. We're not paying for that. And Medicare actually has the right to pursue those no-brainer claims for them. You grew a bed sore. We're paying for care at the next rehab hospital and the SNF unit to take care of the bed sore. We want our money back. They never do. I've always thought it would be an interesting discussion to have with Medicare. Well, let me handle all of your retained instrument case. And let's talk about how I get your money back for you. As a taxpayer, I'm game for that. All
right, Scott, I'm gonna ask one more question. I'm gonna try to be quiet, then other people ask questions. So one of the problems we have, and you and I talked a lot about this, is if a guardian is going to have either even a lawsuit or even just the start of it, and that ward is still in that same building, what do they do? Because right now there's a guardian talking to me about this every week through our peer mentoring program through here, that he can't find another place for the ward, but he absolutely has a case. What does he do?
Yeah, good question. I'm glad you brought it up because I don't think I touched on it at all. And so from my chair, my general rule is I will not show up on the scene. I won't even get records. I won't get involved if the resident is still in the target facility. Okay. Like every rule, though, I put a few asterisks by it. and one example would be, I think of I say boy, but a young man who was sexually abused in a group home in Central Florida by one of the caregivers. And it was just awful. And they were having trouble. It was some unique condition. I don't remember what it was. And they couldn't get him anywhere else. And I said, you know what? We're going to be willing to take that case. And so is there a concern about retaliation? Well, there is. But the reality is, I think what happens is they know I've got lawyers looking over my shoulder. And when the next facility comes around and somebody whispers in their ear, well, they're suing us already. So go ahead and address that up front if it's something that bad. So yes, I brought a lawsuit against them. Your employee raped my ward. Are you critical of me for that? Well, maybe we should move on to, but it's only those really outrageous cases that just cannot be set aside. But yeah, you want to try to get them somewhere else. But I know you have this problem from time to time. It happens with some of my clients that they cannot get them somewhere else. But I've had cases that we've pursued the claim, even though they're still there, and everybody's uneasy about it. But it's a challenge, and I'm sympathetic to the challenge. I wish I had an easy answer.
All right, Scott, so I can offer for questions. Are you good staying for a few more minutes or you need to run?
I'm good for a few minutes. Yeah.
All right. Okay, so guys, any questions you want to ask? I can ask the one question. Scott, are we able to share your slide with all the folks?
Sure.
Okay, so Kate and
I'll
Julie
send
will take care of that administratively on agent side. All right, so guys,
I'll share that
questions?
petition also.
And that form, that petition. Yeah, I definitely want to see that petition.
Okay. All done?
Well, I get in trouble for not giving people enough time to respond, so I'm trying to be quiet.
Well, thank you all for having me. This is I always like, we become isolated in our own little world sometimes, and it does me well. I'm a better lawyer when I talk to the nursing school, when I talk to the guardians, when I talk to non-lawyers. It helps me collect my thoughts, and it is my world, and it's easy to talk about our own world, but I appreciate the work that y'all do. It's so important for the wards, and I hope you never need me. But we work all over the state, and I work all over Georgia as well doing this work. And currently have claims from as far south as Naples to Pensacola and Jacksonville, and it can be horrible stories that we hear sometimes. But when you get a matter resolved in such a way, and sometimes it's even a matter that doesn't seem like serious injuries, but we can reach a recovery that'll help put a companion or a sitter by a disabled girl's side.
Big deal.
4 days a week for the rest of her life. Let me tell you, I feel good about that,
That's good. That's good. All right. So got a couple of thank yous so much. Greatly appreciated. Couple of folks thanking you and thank you for being here. And Scott, I really appreciate it because y'all don't know on the back end how much time Scott and I spent kind of, weeding through the PI and guardianship, how they meld and how they come apart. And we talked a lot about it. So I am always happy to do these because then I come away better every single time with what I learned even during our conversation. So, all right, guys, I'm going to give you just one more minute so I don't get in trouble. If you want to ask a question, come off a mute, raise that little yellow hand or put it in chat.
Folks are welcome to email me later also.
Oh, yeah, contact information. So we usually put that up on the chat. And then Julie and Kate will send out everything from the presentation today to everybody who attended. Julie, is there anything else we need to do on the admin side?
Just a reminder, the last Wednesday of the month peer is on the 30th. So that's coming up next week. At what time do you guys run that at, Teresa? 5 p.m.?
That's the evening one, 5 p.m. Yeah, and we're going to talk a lot about this aggravating CE broker / OPPG number headache. That's going to be one of our topics that day. Okay, Scott, now you know how to find us. This whole group is the professional and public guardians all over the state of Florida, from Key West to Tallahassee. And we really appreciate your time. And I like the fact that you understand, maybe not like every PI attorney understands, that we really care about these folks. And it's a very tough job we do. So thank you so much for presenting for us.
Thanks so much for having me. Thank you.
All right. Good night, everybody.
Good night.